Employment, immigration, and labor law. We're going to have a short lecture on this topic, but we want to make sure that we have some of the more essential elements of employment law listed before we move to the next chapter on employment discrimination and harassment. First of all, most states, including Alabama, follow the legal doctrine of employment at will. And employment at will is a doctrine that says that an employer or an employee can terminate the relationship at any time for any reason, good reason, bad reason, or no reason at all, as long as it's not for a federally protected reason, generally federally protected. There are some state laws that sometimes apply. In Alabama, generally federal laws will prevail because they are more significant than the state laws. And what this means is, as an employee at will, that your employer could someday decide to terminate you because he didn't like the way you said good morning to him. Or I've had potential clients that have talked to me before and told me that they were wrongfully terminated, and I asked them how they were wrongfully terminated, and they said, well, that they were late one day and the employer terminated them, even though the employer had many other employees that had many other late days, and they suffered no adverse consequences. And they said it's not fair. Well, employment law, like most other areas of the law, isn't about what is fair, but it's about what is legal. And something may not be fair, something may not be ethical, something may not be moral, but it still may be legal. And the employment at will doctrine says that you can terminate someone for even a bad reason, such as them not liking the fact that you're a Kentucky football fan, for example, as long as it's not one of the reasons that typically we're going to talk about next chapter, such as discriminating on behalf of or because of one's race, religion, national origin, sex, that kind of thing. One thing that I want to point out is that the relationship between an employer and an employee is a contract. And even if it is not in writing, as we know, a contract does not have to be in writing to be legally enforceable. It can be a verbal contract. However, an employment at will contract means that either party can breach the contract at any time without any consequences. Employer agrees to pay employee $20 an hour for working for this week. And the employee decides on Wednesday they've had enough and they leave. If the employment at will doctrine did not apply, the employee would then have to pay the employer for breaching that contract. But because it's an employment at will doctrine, either party can terminate the relationship at any time for any reason. Most of the time we think about it in terms of the employer terminating the employee and not owing them anything because the employment at will doctrine says they can terminate for any reason, but it does work both ways. There are some exceptions to the employment at will doctrine. I just really want to talk about one or two little exceptions. One is if there is a contract, and I'm going to go to an express contract. If Nick Saban coaches the University of Alabama's football team, he more than likely has a written document, a written contract that outlines his duties and responsibilities along with his salary. And it also provides that the University of Alabama has the right to terminate him if they choose. However, if they do, they must pay for that. That's a buyout type of provision. But basically what they're doing is that's really liquidated damages. As we have learned in under general contract law, is just an estimate of what the actual damages really are in cases where they may be difficult to estimate. And that's really what a contract like that would apply. There are some exceptions based on different type of tort theories. They're pretty rare, and I'm not really going to get into it in this area. It's more of a tort-based system than not, related to fraud and things of that nature. Whistleblowing, or the QUITAM, Q-U-I-T-A-M Act, is a potential exception that protects an employee from being terminated in the event that they turn their employer in for violation of some sort of federal or state law. It's basically a whistleblower protection type of provision, and it's an exception to the employment at will doctrine. But really, in my mind, it's not so much of an exception as it just doesn't apply. The employment at will doctrine says you can hire or fire someone for a good reason, bad reason, or no reason. However, it does not apply in the event that there is a federally protected or some state law that protects you, and this would be in that category. So it's not really an exception, it just doesn't really apply. There are several wage and hour laws that are applicable. The Fair Labor Standards Act is the one that we're going to discuss, and there is a separate handout on this as well that I recommend that you review and study. Everyone knows the Fair Labor Standards Act provides that a party is entitled to their regular hourly wage for the time that they work up until the 40 hours a week. But if they work more than 40 hours a week, they are also entitled to time and a half, overtime. Now that doesn't apply to everyone. That applies only to those workers who are considered non-exempt employees. A full discussion of that is beyond the scope of this class, but in general, an exempt employee is an employee who has a salary of a certain dollar amount, and I'm careful with that. At the time of this recording, it's $23,000 plus per year, but there's a regulation that may change that to $47,000. You just have to check and see what it is at the time of the action. And for those people who have a salary exceeding that and who have a managerial supervisory position of authority, then they are not required to be paid overtime. So you might have the president of a bank earning $500,000 a year for a small bank, and that bank president would not be entitled to overtime if he worked more than 40 hours a week. But you might have a bank teller, and the bank teller, almost regardless of their salary, would not be a person in a managerial type of position of authority, decision maker, and they would be entitled to time and a half for all overtime in excess of 40 hours per week. Now, a couple things to note here. One is that that's 40 hours per week that must be exceeded for overtime to apply. It's not 8 hours a day. A person can work 10 hours a day and they're not entitled to overtime as long as they don't go over 40 hours in a work week. Now here's the second thing that's very, very important. A work week is generally defined by the employer. Your work week could be Monday through Sunday, like many are, or it could be Thursday through Wednesday. On an exam, I can give an example of someone that works 10 hours on Tuesday, 10 hours on Wednesday, 10 hours on Thursday, 10 hours on Friday, and 10 hours on Saturday. That's Tuesday, Wednesday, Thursday, Friday, Saturday, 5 10-hour days, 50 hours during the week. And I might ask you if that employee is entitled to overtime. And the answer, without other information, is I don't know. If the work week is Monday through Sunday, then yes, they are entitled to overtime because clearly they have worked more than 40 hours during Monday through Sunday. Tuesday through Saturday, they worked 50 hours. One if the work week were, let's just say, Thursday through Wednesday, then one work week ended on Wednesday, and so they had 20 hours on Tuesday and Wednesday, 10 hours on Tuesday, 10 hours on Wednesday. That work week ended. The new work week started on Thursday. They worked Thursday, Friday, and Saturday, and they only had 30 hours at that point for the new work week. So be very careful of that because the work week will determine whether or not they are entitled to certain overtime. I have pulled up the handout that is contained on the blackboard regarding the Fair Labor Standards Act, and it has some additional key points that are not listed in the PowerPoint. We've just talked about the first, second, third, fourth, and fifth bullet points on this handout. The last two, much abuse takes place in classifying non-exempt employees as exempt. And there have been some very large judgments rendered against companies. There was a small department store chain that engaged in the practice of making many people assistant managers. You would have Joe Johnson, who was a store clerk, and he was making $10 an hour, and they'd say, "Hey, Joe, how would you like to be promoted to assistant manager?" He said, "Great." And they said, "You're making $10 an hour, working 40 hours a week, you're getting $400 a week. Now what we're going to do is we're going to pay you a salary of $450 a week." And Joe would accept, thinking that he had received a raise and was going up in the world. When instead the company then said, "Now, Joe, because you are an assistant manager, you have to show up not only on the days you're used to working, but also other days as well. Now we're going to have you working Monday through Saturday, 10 hours a day, and you are on salary, so you're not going to get paid the $10 an hour for those 60 hours that you work, but instead you're going to get paid $450 salary." So instead of really receiving a raise, really Joe had gotten a pay cut. And his job duties had not changed. He was still a store clerk. He still stocked the shelves, checked out customers at the register, helped sweep the parking lot, etc. When those things happen, they can result in very large judgments against the employer. So be very, very careful on how you classify workers so that you don't misclassify your workers. And the final bullet point is one that is pretty interesting. Had a recent case that I was involved in involving this, that case law requires employees to be paid for wait time, time that they must be on the employer's premises in the event, and there's a typo there, it should be must be on the employer premises. If they're required to be there, even if they don't have to do any work, then case law says you got to pay them. They must be paid for that. It's their time. You're taking away their free time, so you've got to pay them for that. I was involved in a case where we filed against a restaurant chain nationwide that had their employees who were servers clock out and then settle up with the manager on what their receipts were for their shift. And that was time that they were required to be on the premises, but they weren't getting paid for it. Sometimes it might only take 5 or 10 minutes for the employee to settle up for the manager. Other times, if there were 2 or 3 or 4 employees that were ending their shift at the same time, depending upon when you checked out and settled up with the manager, it could have been a half an hour, 45 minutes, an hour or more, especially if the manager was interrupted and had to do something else. In our particular case, the employee was absolutely prohibited from leaving the premises until they settled up with the manager for obvious reasons. They didn't want to have anybody skipping out with money that belonged to the restaurant and not properly settling up before they left. So they were required to be on the employer's premises, but they weren't getting paid for it. We filed suit, arbitrated the case, and got a very favorable resolution on behalf of all of the employees. The last thing that I want to cover in this chapter is regarding the Family and Medical Leave Act. The Family Medical Leave Act is a federal law that says that any employer who has over 50 employees must provide up to 12 weeks of unpaid leave to an employee per year if they have a need to take care of a sick, I'm going to call it close relative. The PowerPoint slide says a spouse, child, or parent. Certainly all of those would qualify. Case law has extended that beyond just a spouse, child, or parent, so I'm just going to say a close family relative. And you have to check it to see if it's your fourth cousin, third removed, that's not going to qualify. But if it's your long-term common law husband, then probably that's going to work. Now, there's many different aspects to this that make this sound better probably than it is. But the first caveat is that it's unpaid leave. Not many of us can afford to take 12 weeks, which is right at 3 months, almost 3 months, of unpaid time off from our employment. We have to work to earn a living, and we have to be paid. So that's the first kind of protection to the employer. The second protection is that it only applies to ones with over 50 employees, and that's to prohibit someone needing to take off for 12 weeks at a company that has 6 employees, and that company not being able to hire anybody, because who's going to go to work for a company that may not need them in 12 weeks when the other person returns? So it may be very difficult to fill that position. And so the Family Medical Leave Act requires the company to be of a certain size, to be over 50 employees before it applies. Now, if it applies, then the company doesn't have to keep the employee's same job open, but they have to keep their same job or a similar position available upon returning to work. I had a potential case once where I had a lady that worked for a medical provider, and the medical provider was a large company. Certainly the Family Medical Leave Act applied. She went on Family Medical Leave Act to take care of a particular situation, I think with her mother. And when she returned, they no longer had the job that she had available. So they offered her another position making the same pay. And she came to see me and she said that while it's the same pay, it's not really the same kind of work, and it doesn't have the same opportunity for me to grow in the company and to be eventually promoted. In short, it just wasn't as good a job. And she was interested in finding out if she had any rights under the Family Medical Leave Act, because in her mind, they did not keep either the same position or a substantially similar position available to her when she returned to work. Now, I wish I had an answer for you because the case never got started. She ended up finding a job almost right away with another company, making more money, better job, better opportunities for promotion. It all worked out well for her, and we never really had to finish doing the research on whether she had any rights or not. But just be aware that just because it's the same money may not mean it is a similar position. It may be similar pay, but it may not be a similar position. And so that's something also to keep in mind. And that's all that I'm going to have under the Family Medical Leave Act and Employment Law Introduction. Thank you very much.